Good afternoon. My name is Gary Kibel, and I'm a partner at the law firm of Davis & Gilbert in New York. And I practice mostly in the areas of digital media, privacy, and data security. This afternoon, as part of the Institute for Advertising Ethics, we're going to talk about privacy compliance as a part of a data ethics program. And we will have a presentation for about 20 minutes or so, and then when the presentation is over, we can have a Q&A and conversation. So with that, I'm going to share a couple of slides to guide us through our conversation. So let me go ahead and share my screen and make the presentation full screen here. Okay, so let's get started here with a couple of slides, privacy compliance as a part of data ethics. The few things I'm going to talk about today are, firstly, a difference between the philosophy on privacy laws between the US and the EU. Then we're going to spend most of our time talking about the California Consumer Privacy Act. This is a groundbreaking new law in the United States and really impacts how privacy is being applied in the US market. We'll talk about some other states besides California. Then we'll talk about these entities known as data brokers. And there are more laws that are applying to those who might be considered data brokers. Lastly, we'll talk about what's happening on the federal level. So the US versus Europe, there's a very, very different approach to how privacy is handled in those two jurisdictions. In the EU, many of you have heard of the GDPR, the General Data Protection Regulation. This is a very lengthy law. It has 99 articles and 173 recitals, and it governs privacy through all different industries, sort of at the equivalent of the federal level. Whereas in the United States, on the federal level, we do have sectoral laws that apply to children or healthcare or financial services. But as far as a law that is an omnibus law that covers all different industries with respect to privacy and data security, we just have one sentence. It's one sentence from Section 5 of the FTC Act about unfair methods of competition in or affecting commerce, and unfair or deceptive acts or practices in or affecting commerce are hereby declared unlawful. That's it. It's that one sentence. Deception is a misrepresentation or omission that's going to mislead a consumer. So if your privacy policy says we're only going to use data in a certain way, but you end up using data in a different way, that can be deception. Unfairness. What is that? That's something that causes or is likely to cause substantial consumer injury. Doesn't actually have to injure a consumer. What might be an example? You collect personal data on a consumer and you don't keep it secure, and there's a security breach. The FTC could deem that that is an unfair act. As I mentioned, there are many other laws in the United States that deal with privacy or data security, but in a particular context. COPPA for children, HIPAA for healthcare information, GLB for financial information. There's the CAN-SPAM Act with email marketing. But there are all these different little components. We don't have this one overarching law like they do in Europe. And for security breach, there are 50 different state security breach notification laws. So when you have an incident, it's very hard to comply because you have so many different standards. So the definitions are also very important because you may hear people in the industry talk about PII, personally identifiable information. Well, what does that mean in the United States? It really depends upon what legal regime you're operating under. COPPA has its own definition of personal information. HIPAA defines protected health information. Gramm-Leach-Bliley defines non-public personal information. This is different than the EU, where there is one definition for personal data, and that applies to every industry and every practice. It's a very, very broad definition, but it's much easier when you're dealing with one definition. So in the US, if someone says to you, we collect PII or we don't collect PII, that's a very hard thing to analyze because we don't know what they're talking about. That doesn't mean one thing. So along came the California Consumer Privacy Act. It's the nation's first comprehensive consumer privacy law, and that's why it's such a big issue. So let's talk about some of the history of the CCPA and how we got here. So it's been kind of a crazy history. So it's tough to get your arms around how we got here. Starting back in 2017 and 2018, there was a group in California that started a ballot initiative, meaning they drafted a law that was going to be put on the ballot in California for the voters of California to vote upon. That law would have been very, very restrictive on the industry. So there was a negotiation between the sponsors of the ballot initiative and the California legislature, and they came up with a law that was passed in June of 2018. The agreement was that if the California legislature passed a law by the end of June, the signatures for the ballot initiative would not be submitted and it would not appear on the November 2018 ballot. So CCPA was written and passed unanimously in just a few weeks. It had typos, it had inconsistencies. It was not the cleanest bill ever put together. There were some cleanup amendments that were passed in September of 2019. And then one of the requirements of the law is that regulations have to be issued by the California Attorney General. The first draft of the California CCPA regulations came out in October of 2019. Then in 2019, December, the industry launched some initiatives for compliance, which we'll talk about in a moment. Then the law took effect in January 1 of 2020, but the regulations were still not final. Final regulations were just released last week. Think about this. The law has been in effect for 6 months, but we don't know the final rules until just last week. There was an amendment which delayed enforcement until July 1 of 2020, and that enforcement is just about to kick off. So, what are some of the key rights under the CCPA? Well, firstly, it requires greater transparency and privacy policies. The law and the regulations talk about specific items that must appear in your privacy policy. So if you have a privacy policy that was drafted pre-CCPA, almost guaranteed it does not comply with that law. The law gives consumers 3 key rights: a right to know what information is being collected about them, a right to request that data be deleted about them, and a right to opt out of the sale of their personal information. It's important to keep in mind that CCPA is an opt-out law. This is not an opt-in regime like some requirements under GDPR. If you fall into this requirement of having to offer consumers the right to opt out of the sale of your personal information, you may need to put a link on the homepage of your website with the actual words, "Do not sell my information" or "Do not sell my info." We'll get into this a little bit more as we move forward. So who's covered by the CCPA? It doesn't apply to everybody. Firstly, it only applies to for-profit entities. It doesn't apply to not-for-profit entities. But it applies in the B2C context and the B2B context. It applies to companies that are doing business in California and that collect consumers' personal information. Number 2, determine the purpose and meanings of processing of that information, and then meet one of 3 threshold tests: more than 25 million in annual gross revenue. Annually, you're processing 50,000 or more records of consumers, households, or devices, or you derive 50% or more of your annual revenue from selling personal information. Affiliates that share common branding can all be grouped together in the same business, but there is a carve-out for certain businesses that are already regulated under existing financial services or healthcare privacy laws. Of those 3 components in C, the one that is the easiest for most companies to trip up on is 50,000 or more records. Just think about your website. If you cookie users on your website, it's very easy to get to the 50,000 number during a year. So who is a consumer? Who is a California consumer? Because it only applies when you collect personal information from California consumers. A consumer means a natural person who is a California resident, however identified, including by a unique identifier. Well, who's a California resident? The definition is every individual who's in the state for other than a temporary or transitory purpose, and every individual domiciled in the state who is outside the state for a temporary or transitory purpose. That's a very strange definition. The reason it's a strange definition is it comes from the California Revenue and Tax Code. So They were thinking about people who live 8 months of the year in California and 4 months of the year in Lake Tahoe. It's very difficult to apply that to the online world, but that's what we're dealing with. So CCPA does have an extraterritorial effect. You don't have to have your company physically located in California for the law to apply to you by these definitions. Under the law, you're either a business, a third party, or a service provider. Who are these parties? Let's make it very simple. A business is sort of the owner of the data, the one who determines how the personal information is going to be used. A third party, we'll come to that one at the end. A service provider is one, as you would intuitively think, one who's providing services to a business. It may be a hosting provider, or one that's helping with, some direct marketing or doing things in the background, and they follow the instructions of the business. And in general, they don't use the data for their own purposes. But there are carve-outs now under the regulations which allow service providers to do certain things internally with the data for their own benefit. A third party is anyone else. Anyone else who's getting the data from the business and they're not a service provider. So that may be parties that you're truly selling the data to who can use it for their own benefit. Lawyers, we like to harp on definitions because definitions drive everything. It depends how you define something. So again, remember I talked earlier about there's no definition of PII. So under CCPA, there's a definition of personal information. And the reason this law is so impactful is because the definition is extremely broad. It covers not just someone's name and email address or postal address. It covers online identifiers, IP addresses, browsing history, geolocation, inferences drawn from this data. So it's incredibly broad. So if you are dropping a tracking cookie from a website, that's a persistent identifier. That is personal information. The right to know. So what is the right to know? What do consumers have the right to ask you? They have the right to ask you about the categories of personal information collected, the categories of sources from which it's collected, your business or commercial purpose for collecting or selling the information, the categories, not the individual, but the categories of third parties to whom you share the information, and then the specific pieces of data you collect. And you generally have 45 days to comply with this request to know. So what is the sale opt-out? You may think to yourself, well, I don't sell data. That's not the business I'm in. But just as the definition of personal information was incredibly broad, the definition of selling is incredibly broad. What does it mean to sell? It means to sell, rent, release, disclose, disseminate, make available, transfer this data for monetary or other valuable consideration. So basically, if you're allowing the personal data, personal information, to go to another party and you're getting some benefit out of that transfer, that's a sale of personal information. If you then fall within that category of selling personal information, you're required to have a clear and conspicuous link on your homepage with the actual words, "Do not sell my personal information," or "Do not sell my info." You'll start seeing these links around the internet now, and a lot of companies don't want this link on their website because it kind of freaks consumers out and makes them think that there's some, wholesale business of selling their personal information for cash, which that may not be the case. All that may be happening is there's a tracking cookie on the website and the data from that tracking cookie is being shared with other parties. So there are examples out there already on the internet. You look at the bottom of a website and you'll see a link, "Do not sell my personal information." It may just deep link to a portion of the privacy policy. There are some that when you click on the "Do not sell my info," it may have a portal which allows you to exercise certain rights. The law doesn't say specifically what you must have when the link is clicked. There have been a number of amendments to the CCPA. Most importantly is a carve out for certain obligations with respect to employee data. It doesn't carve out every obligation, but certain obligations have been carved out with respect to employee data, but the carve out only applies until January 1st, 2021. So if that amendment is not extended or rolled into some other law, these CCPA obligations may apply to employees. So the regulations, as I mentioned, the final version was just issued last week. It's still waiting for the official certification, but we finally have the final draft. And the challenge with these regulations is there's a lot of things in there that are not in the law itself. They are just things that appeared in the regulations that the Attorney General's office drafted. There are things about privacy policy changes, just-in-time notifications for mobile. You have to make your privacy policy accessible to those who are visually impaired, pursuant to a specific standard, WCAG 2.1. There's talk about compliance with do not track signals. As I mentioned, there are some carve-outs for service providers so they can use data internally for their own purposes. And there's even talk about data security, which was not part of the original law. I could spend an hour talking about the regulations, but just something you need to read and look into. Most importantly, with CCPA, there's no private right of action. Individuals cannot sue you privately unless you have a security breach. The only thing that can happen is the Attorney General's office can bring an action against you, and they do have the right to issue statutory damages. So in the ad tech and interactive world, how is this being dealt with? Well, one of the initial challenges is what's collected in the interactive world personal information? And the industry has come around to realizing that persistent identifiers collected through tracking cookie and pixels and tags, that is personal information. So then what are ad tech companies? If you have a pixel provider on your website, are they a business? Are they a third party? Are they a service provider? The general view is that if that pixel party, that party that's dropping the cookie, can take the data and roll it into a profile and sell it for their own purposes and use it for their own activities beyond those of just that publisher website, then they are a third party. So when you piece this all together, the publisher website is a business, the ad tech company is a third party, and you need to provide consumers the ability to opt out. How is that being done? The Interactive Advertising Bureau has come up with a CCPA compliance framework to allow publishers and third parties to work together to manage these opt-outs. If someone exercises the right to opt out, all it does is convert that third party from a third party into a service provider. Again, it's a very complex system, but a very valuable system, which we could explain at another time. And one more thing back there, the CCPA deletion tool. Literally just a few days before we put this presentation together, the IAB announced a CCPA deletion tool that's going to help with publishers and service providers. There's another organization, the Digital Advertising Alliance. They also have a CCPA opt-out tool, which may be something that a publisher wants to look at. You can click through there and then opt out of specific sales to specific companies. Some companies have their own procedures. Google has a program called Restricted Data Processing, RDP. If you have Google enabled on your website and you're a publisher, you want to log into your Google account and see which programs and products are already set for RDP and which ones you need to turn on. It basically tells Google to stop acting like a third party and start acting like a service provider. The Attorney General said we'll look at companies kindly who are trying to comply. They were trying to indicate that, look, perfect compliance is going to be hard to come by, but you got to get there. This quote really applied maybe in the January to July timeframe. Once we get past July 1st and enforcement starts, I don't think your best college effort is really going to be enough. You really need to be in full compliance. We help companies sometimes put together compliance plans, but that's maybe beyond the scope of this presentation right now. So what should you be doing right now? I think you should be updating privacy policies. You should be understanding your data, what data you collect, where does it come from, how it's used. Really understand the other parties you work with. Are they third parties? Are they service providers? If it's a service provider, you need to update your contracts and have a service provider addenda. You have to have a plan in place to respond to these consumer access requests. Most companies may not have a procedure in place already. Update your form agreements to deal with CCPA issues. And if you're in the ad tech ecosystem, you're an advertiser or you do advertising or you're a publisher, you need to understand where you fit in the ad tech ecosystem and what your obligations will be. I'll do a quick compare and contrast with GDPR. Again, they're very different. Again, CCPA is an opt-out law, whereas in GDPR, you need to establish a legal basis for any processing of personal data. The territorial reach is a little broader under GDPR. The definitions of personal information and personal data are a little different. There are different types of access rights. CCPA is not really focused on internal data security, whereas GDPR has a heavy internal data security focus. GDPR has requirements about audits and breach notification. That's not part of CCPA. CCPA introduced this concept of having your website accessible to those with disabilities who are visually impaired. That's not part of the GDPR. GDPR has requirements about having a data protection officer and cross-border data transfers. Again, CCPA, we focus on that sale opt-out. There are different definitions about business, service provider, third party versus a data controller and data processor. I mean, just look at that. CCPA, you have 3 different parties. GDPR, you have 2. And the fines can be very different. Under GDPR, it can be 4% of annual revenue or 20 million euros. That's pretty significant. Okay, little known fact. There are actually 49 other states in the United States besides California. We don't have time to go through all of them. And I'm looking at the clock here. I think we may race through some of this very quickly. You can feel free to contact me offline if you have questions about some of these issues that I'm racing through, so forgive me. And we can also talk about some of this during the Q&A. The trend in state laws is to move away from notice and choice and talk more about transparency and data access. There are a number of laws that have been proposed, but have not yet passed. And I think more states are going to be aggressive in this area. Washington State came the closest to having a very comprehensive law, but it didn't pass. But I think it could come back. Had some elements that were similar to CCPA, some other elements that were similar to GDPR. One state, in New York, just quickly, my home state, we have the New York Shield Act. This law has been enacted. It's now a statutory requirement to have reasonable security procedures and a security program. And the law has specific elements that need to be in that internal data security program. One state that did pass a law is Nevada. And again, forgive me for skipping some slides here. Nevada implemented a law that only applies to the right to opt out of the sale of personal information. It's not an access law. It's not a transparency law. It's just the right to opt out of personal information. This law became effective last October, so it's been in place for a while. It applies to covered information, which is a little narrower than CCPA personal information. And the definition of sale is actually much narrower. It's really a sale of that covered information for money, for cash. It's not just some value exchange. So that law is currently in effect. If you get requests, a verified request from Nevada, you have 60 days to respond to the request. It applies to information you've collected or will collect. So there's some, forward-looking aspect of this law. And enforcement, again, is by the Attorney General, no private right of action. Okay, let's try and get to the home stretch here so we can get to the Q&A. There's always been a focus on big data. What is big data? Sort of these data brokers in the background that are collecting and selling information. The Federal Trade Commission, as far back as 2014, was lamenting the lack of transparency in this industry and the fact that consumers have no control over who is buying and selling their information. There's this view that there's unchecked data out there, and this is an unfortunate example about a mailer that somebody actually received in the mail that said, Mike Say, daughter killed in car crash or current business. There are data brokers that have unbelievable amounts of data on all of us. Now, sometimes this data is used for a very legitimate purpose. Maybe this data was being used to suppress certain offers. They would not go to this individual. But that data is out there and it's being bought and sold, and consumers can't control it. I experienced this myself. My son, Spencer, got a wine catalog at home. And I was a little surprised that he got a wine catalog because at the time, wine was not really the thing that he was interested in purchasing. So just an example of poorly purchased data. So there are now a few data broker protection laws in the United States, Vermont and California. Vermont was the first one. It simply requires a data broker to register with the state. It's a bit of a transparency issue. Who's a data broker? It means a commercial entity that collects and assembles, maintains personal information of residents who are not consumers or employees of that entity. So a data broker is truly that company in the background that a consumer may not know exists. It's a registration requirement. California now has one, which has gone live this January. The last time I checked, over 300 companies have registered as data brokers in California. The definition is very broad. It's a business that knowingly collects and sells to third parties the personal information of a consumer with whom the business does not have a direct relationship. Everything else kind of pulls from the CCPA. So it's very broad, and a lot of companies are registering. So if you fall into this data broker world, you need to register. The interactive world, I'm not going to go into this in too much details. There are self-regulatory programs for behavioral advertising. There are certainly programs through major portals. Big change in the industry that Chrome is going to disable third-party cookies in less than 2 years. So if you're in that ecosystem, there's a lot of things for you to focus on. What's going to happen on the federal level? Well, there have been a lot of laws proposed on the federal level. None have really made it through committee. If you had asked me 6 months ago what the likelihood of a comprehensive federal privacy law was going to be, I would have said a very good chance. Now, there's just so much going on the federal level, I don't really see that happening. So with that, hopefully that gave you some information about the privacy laws that apply in the US. And if you're dealing with data and being a good ethical party in the ecosystem, compliance with all these different privacy obligations is really critical. And it's challenging. It's challenging because there are so many different laws in the industry. If there was one, it would have been very simple. But we have so many different laws that we have to comply with. And you just have to look at your business, look at where you're conducting business, understand the data you're collecting and processing, and then build a compliance program around them. So with that, I'd like to take your questions, and let's put your questions into the chat, and we'll have some Q&A.